This is Mike Nemeth, Marketing and Communications Director for the California Apartment Association. Welcome to our latest vidcast, where we're going to be going through some of the biggest news stories affecting the rental housing industry here in California. Let's start with the County of Los Angeles, where the Board of Supervisors last week took significant steps toward creating a right to counsel program. The cost? Up to $60 million per year. The county doesn't know where that money would come from, except it would be public dollars. The program would start with low-income renters in unincorporated parts of the county and eventually move to the cities. Now, the California Apartment Association opposes creating this ordinance, pointing out that these types of programs are largely ineffective. Here's Fred Sutton, CAA's Senior Vice President of Local Public Affairs in LA, making that point to the County Board of Supervisors.
The Shriver study found that legal counsel was not effective in preventing the removal of a tenant from a unit. Overwhelmingly, the resident was required to move out of the unit at the end of their case. RTC only delays the process. The housing shortage and correlating affordability issues does not need a legal solution. It needs an economic one.
If the county is intent on spending taxpayer dollars for this issue, it would be better served to subsidize the rents of struggling tenants. That would make sure the tenant stays housed and the landlord is compensated.
It costs thousands of dollars to provide legal counsel for one case. Tax dollars can go much further through a rental subsidy, helping more of those in need, preventing a potential eviction, and at lower cost per individual.
LA County staff has about 10 months to come back with an ordinance for the supervisors to consider. When that happens, we may be coming to housing providers in Los Angeles County asking them for help fighting this proposal. Now, from the state capitol, the California Apartment Association has expressed its continued support for legislation to protect property owners from trespassing incidents. The proposal, Senate Bill 602 from Senator Bob Archuleta, aims to extend the validity of trespass authorization letters, also known as 602 letters, from 30 days to 12 months and up to 3 years if the property is indefinitely closed and posted as such. These 602 letters, which are allowed under Section 602 of the Penal Code, can be filed with local law enforcement by property owners. They request that law enforcement respond to incidents of alleged trespassing, and it's become an essential tool for property owners, particularly in light of a reported increase in trespassing incidents at properties closed for repair or within retail spaces of mixed-use buildings shuttered as a result of COVID. Now, CAA has expressed the difficulties that property owners face, including incidents where trespassers refuse to leave and in some cases have been able to persuade law enforcement that they are actually authorized to be at the property. And this can lead to substantial damage, including graffiti, theft, and destruction of building materials. This important piece of legislation is now on the Assembly floor, and lawmakers are expected to take it up when they return from their summer recess on August 14th. Also from the Capitol, CAA has secured significant amendments to SB 567, legislation that originally would have imposed severe restrictions on evictions in California, and it also would have significantly lowered the cap on rent increases under AB 1482, or the California Tenant Protection Act of 2019. This bill, by Senator Maria Elena Durazo, has been revised to largely uphold that state law. Key revisions include expanding the definition of property owner under the bill. Initially, it would have only recognized individuals with an interest of 51% or more as an owner. Now that's been expanded to family trusts, and further expansions of that definition of ownership are under consideration. This will help to uphold the current process for removing units from the market and being able to move family members in. Another big change in the bill, initially it would have drastically reduced the amount that landlords can raise to rent each year for housing that's covered by AB 1482. Thanks to CAA's advocacy, the rent cap under AB 1482 will remain the same, and that's 5% plus the change in rate of inflation, or a maximum of 10%. An additional amendment being considered would protect rental property owners from penalties when they inadvertently make mistakes while attempting to follow the law. The bill now heads to the Assembly Appropriations Committee, which will take it up after the summer recess. That wraps up today's vidcast. Thanks for tuning in. Until next time.